When a family gets involved with the child protection system, the path forward can feel like you're lost in a maze. So, what we're going to do here is walk through the Nebraska Child Protection Court process step by step. The goal is to give you a clear map for what is, let's be honest, a very difficult time.
Look, if you're watching this, chances are you're facing a situation that is incredibly stressful and confusing. Our goal is not to add to that. It's to give you a simple, clear map of what you can expect, who you're going to meet, and what your role is in the whole journey ahead.
Okay, before we dive in, I have to put this out there, and it's really, really important. What we're talking about today is general information to help you get your bearings. It is absolutely not a substitute for real legal advice. Every single case is different, so for any questions about your specific situation, you have to talk to your attorney. All right, with that out of the way, let's talk about what it's like when you first enter the court system. Right from the very beginning, the single most important piece of advice boils down to one simple thing: communication. This right here, this is the bedrock of everything else we're going to talk about. Your caseworker and your attorney are your lifelines in this process, but they can't help you if they can't find you. A missed call could mean a missed court hearing or a missed service, and that can have huge consequences for your case. So your number one job right out of the gate is making sure they can always get a hold of you. But good communication is just the start. To really be an effective advocate for yourself and for your family, you've got to understand that you have both rights and responsibilities. Let's break down what that means.
And what's so important to see here is how these two sides are totally connected. They work together. For instance, you have the right to an attorney and a written case plan. Your responsibility is to actually work with that attorney and participate in the plan. You have a right to see your child. You have a responsibility to show up for every single one of those visits. They're really two sides of the same coin.
The best way to think about your case plan is like a roadmap. It's a guide to get your family back to a stable place. It's going to spell out exactly what you need to do, what services you need to complete, and what the goals are. So your job really is to know this roadmap like the back of your hand and, just like it says here, follow through on every single step. Okay, so along this journey, you're going to meet a bunch of different people. Knowing who's who and what their job is can make this whole experience feel a lot less intimidating.
First up, the judge. This is the person who makes the final calls. The judge listens to everybody in the courtroom, but at the end of the day, every single decision they make is guided by one thing and one thing only: what is in the best interest of your child? Understanding that is key to understanding the whole process. Then there's your attorney. Think of this person as your champion, your guide through all the legal stuff. Their job is to be your voice in court, to make sure your rights are protected, and to translate all that confusing legal language. And listen, this is so important. If you can't afford an attorney, the court will appoint one for you. That is your right. You'll also be working closely with a caseworker. This is the person from the Department of Health and Human Services who's your main day-to-day contact. They're the ones connecting you to all the services in your plan, and they're the ones who report back to the court on how you're doing. Building a good working relationship with them can make a world of difference. And finally, you'll hear the term guardian ad litem, or GAL. Now pay close attention to this part. The GAL is an attorney, but they are not your attorney. The judge appoints them for one specific reason: to be the lawyer for your child and to speak up for what's in their best interests. All right, so we know who's involved. Now let's get into the what happens when, the actual timeline of the court process itself. If you zoom out and look at the big picture, the whole thing follows a pretty set schedule. It kicks off really fast with a hearing just days after it starts. Then you have these major hearings within the first 3 or 4 months that establish the facts and create a plan. After that, it's all about regular check-ins to see how things are going. So let's break down those first 3 hearings, because they happen fast and they're super important. The protective custody hearing happens almost right away, and it's all about immediate safety. Then you have the adjudication hearing, which is basically a trial where the judge decides if the allegations are true. If they are, that leads to the disposition hearing, and that's where the judge officially orders that case plan we've been talking about. Okay, so after that initial rush of hearings, things move into a different phase, more of a monitoring phase. You'll have review hearings about every 6 months for the judge to check on your progress. And all of these lead up to a really critical one called the permanency hearing, which happens within a year. That's where the court makes a decision about the long-term goal for your child, and the main hope is always a safe return home. So, with all these hearings, all these plans, what's the point? What's the end game here?
It is so important to understand what the state is required to do for you and what the potential outcomes are. There's a really key legal idea you need to know, and it's called reasonable efforts. This isn't just a friendly suggestion. It is the state's legal duty. They have to provide services to help your family succeed. They have to show the court that they've made a real, genuine effort to help prevent your child from being removed in the first place and to help create a safe way for them to come home.
But, and this is a big but, you have to understand that there is a clock ticking. Federal law is very clear on this. If a child has been in foster care for 15 out of the last 22 months, the state might be required to file to end your parental rights. This is a hard deadline, and it really shows why it is so urgent to start working on your case plan from day one. And that clock, it leads us to the most serious outcome possible. It's called termination of parental rights, or TPR. And it is exactly what it sounds like. It is a permanent court order that legally severs the relationship between a parent and a child. This is why taking this process so seriously and engaging with every single service is just absolutely critical. So, after hearing all of this, the people, the timeline, the stakes, which are incredibly high, it all really comes down to one simple question. What is the single most important thing that you can do? And the answer is surprisingly simple, but it's everything. It's active participation. It's not just about going through the motions. It's about really engaging with the services, communicating openly with your team, and using your time with your child to practice new skills. It's about showing the court, through your actions, that you're building a safe and stable home. Look, at the end of the day, it's so easy to feel like this whole process is just something that is happening to you, but your engagement, your participation, that's the one thing you can always control. Your active involvement is, without a doubt, the most important step you can take on this path.